Hey, it's Julie Schmidt. Welcome to my channel. In this video, we're going to be answering a tort of negligence problem question together. So I just made up a fake question literally like 10 minutes before I've started filming this, and it is very similar to a lot of the questions I have seen both in my own time studying, and I've been tutoring students for about 5 years now. So I have seen a lot of different problem questions and it's very similar. And I also recently created a template which you can download for free, which is about how to answer tort of negligence exam questions. So this is the template that I've just made for answering tort of negligence problem questions. And I just wrote a problem question, like I said in the intro. It's based on a lot of the problem questions I've read over the past 5 years I've been tutoring and also during my own time. So I'm just going to read it out loud to you. Erin, which is my middle name, which is why I chose Erin, she was out late one Tuesday evening. She had been at a friend's house with a couple of mates. They had a tradition where every Tuesday evening they got together and all watched one episode of Bridgerton together. They had a few wines, a bit of chocolate, a few strawberries, and just generally had fun together. Anyway, Erin had finished being at a friend's place and was driving home. She had work early tomorrow morning and wasn't really looking forward to it. She decided to put in her favorite artist, Taylor Swift, to cheer herself up. She opened her phone and quickly typed Tay into Spotify. While she was looking down, she accidentally banged into the car in front of her. The car in front of her was being driven by Timmy. Timmy was on his way to the hospital where he was going to work his night shift as a security guard. Timmy's back bumper had completely crumbled and the car was likely to be ridden off. The car was worth about $3,000. However, the car was a bit of a hunk of junk anyway, and the engine needed to be totally reconditioned. Reconditioning the engine would have cost about $2,000, so Timmy wasn't sure if it was worth it or if he was just going to scrap the car anyway. However, Timmy also had a customized license plate which read "Cool Guy" with a specialty frame around the plate. The frame was gold plated and had neon LED lights around it. It was worth about $2,000. During the crash, Erin totally destroyed this frame. Timmy stopped on the way to the hospital to get Erin's details. He ended up being about 30 minutes late to work. During that time, there was no one at Timmy's security post, and coincidentally, someone robbed the hospital and stole about $50,000 worth of items. It was later discovered that if Timmy had been present, he would have caught the guy and the goods wouldn't have been stolen. So we've got to advise Erin as to any possible liability she may face under the tort of negligence. Alright, so a very standard type of question, at least for New Zealand law schools. First, we're going to lay out everyone who could possibly sue Erin under the tort of negligence. So those are the only possible plaintiff-defendant combinations I can see so far, since there are only 3 parties really involved. After that is duty of care. So Erin is a driver, Timmy is a random driver. We're just talking about people who are driving around in the world. So what we're trying to discover is, do these two have a legal connection? Are they somehow legally connected? I always imagine like a cord between them. Like, is there something linking them legally where Timmy will be able to sue Erin? Because remember, this isn't contract law, so they haven't agreed to being in a legal relationship together. We're just talking about 2 completely random people who somehow end up in this situation. So we're trying to say, are they legally connected? And the test for this in New Zealand, we have the ANS test. So I'm going to go to my notes, and you can buy these on my website. I love these notes so much. I spent so long on them. So we're going to go to the ANS test, and I won't get into explaining it in heaps of depth now because I'm just more showing you the like how to apply legal problem questions rather than actually teaching you the law. But what I would do is I would start off with explaining the law. You can say, to determine whether the parties would, or to determine whether Erin would owe a duty of care to Timmy, the ANS test must be applied. And then I would just double check, what case did they affirm the ANS test in New Zealand? Here we go, South Pacific and Rolls-Royce, I believe. So I go like that. So remember, we are in an exam. You do not need full citations. Okay. So to determine whether Aaron would owe a duty of care, the ANS test must be applied. So ANS 1 is proximity and foreseeability. It must be shown that Aaron was proximate to Timmy and proximate, keep spelling that wrong, and that it was foreseeable that someone in Aaron's position would hit into someone Timmy's position if Aaron were negligent. Okay. We could go more into like the whole neighborhood thing. But that'll do for now. ANS 2. So it must then be shown that there are no legal or social implications associated with Aaron owing a duty of care to Timmy in this situation that would negate Aaron owing a duty of care. Just bear in mind as well, I'm answering this with you, like I haven't pre-thought an answer because I thought it would be better to see the full thinking process. So that's why I am going slower than you might anticipate. So overall in New Zealand, the courts look at whether it's fair, just and reasonable to impose a duty of care. So this would be a potential answer, start of the answer to a problem question in an exam. So applied. Aaron literally hit into Timmy's car. They are literally touching, so they can't really be any more proximate. So I'm not going to spend too much time on that because it's pretty obvious. And in terms of ANS 2, there are likely no policy considerations that would limit Aaron from owing duty of care to Timmy, because in reality it's probably like we want people to be safe on the road, so the courts would definitely want someone in Aaron's position to be liable to someone in Timmy's position. No limitations because we'll just go faster. Just and reasonable to owe a duty of care for sure. Like she hit into him, that there should definitely be there's definitely a legal relationship here. She did something to him and she damaged his car. It's just like a yes. And so we don't really need to link in any other cases here. It's pretty straightforward. We don't need to quote any cases in full. We don't need to explain what happened in ANS or in South Pacific. We don't need to go into the facts of those situations. This is just pretty straightforward. There's nothing too legally tricky in step 1 in this problem question. It's just like, yep, obviously she owes a duty of care to him. She hit into him. Couldn't be more straightforward. So we're just going to leave it at that. So I'm just looking at the people who are learning ILAC or IRAC. We have law. We've got it applied. We've got the conclusion. ILAC. Issue. Yeah, we've got the issue also up here. So you can see people often ask me, do I follow ILAC? I say I do, but I just don't always go ILAC. So I've got the issue and the law kind of mixed up in here, and I've got the application and conclusion mixed up a bit here. Okay, so let's move on to step 2, the standard of care. And the standard of care and the duty of care sound similar. I think it's the of care that throws people off and threw me off, so I can completely relate to that. But what we're looking at here in the duty of care is the relationship. What we're looking at here is purely about Aaron or the defendant and whether they were careless, whether they didn't come up to the standard of the reasonable person in that situation. So let's say Aaron was driving and she did something like she had a heart attack and she had no idea she had any medical issues. And then if you went to sue her, like, that's pretty harsh, right? Because did she even do anything wrong if you're just driving and you randomly have a heart attack and you cause a crash? Like, it's pretty stink to then get sued when you actually didn't do anything wrong. So we're looking at the fault of the party because, yeah, negligence, we're looking at if the person was actually careless and whether they actually did something wrong. So the test comes from Bolam. That's one of the places you can find it. It's an objective test. So what we're looking at is what would an ordinary person in the same situation have done? So I went to my notes there and found a definition. So we can say next, it must be shown that Aaron was not, did not come up to the standard of an ordinary, reasonable driver in the same circumstances. Okay. We can say this must be assessed objectively. That means, like, we're not looking at Erin and whether she's a careless kind of person or like her standard. We're looking at what any person in that situation would do or should have done, right? So what we also want to do is go to my notes, take a look through and see if there are any extra little bits that we can add in. So we've got something here on driving, which might be relevant. The standard is always that of a reasonably prudent driver. All right, so we can add that into our look section. And I want to put in things inherently dangerous have a very high standard of care. So we can add that into the law section. I would rewrite it, but I think that's good enough for now. We've got the legal test, and then we've added 2 pieces of information that are relevant to the situation. What do we think? She was driving. She had hit a few wines. We don't know if she was over the blood alcohol limit or not, but maybe not great. She might have been a bit distracted because she had work. She was sort of daydreaming, potentially. But here's the main one, She looked down and was on her phone. We know that's illegal. So we can say she didn't come up to the standard of care, right? Like, an ordinary person should follow the law and they shouldn't go on their phone when they're driving. So to apply it, then we could go into driving as a high risk activity. All right, so let's look at causation. So did the defendant cause the accident? So the test is, if we go to my notes, it's but for the defendant's lack of care would the damage have occurred. Next, causation in fact must be proven. And that means, like, it sounds more scary or complicated than it is. It just means, like, in reality, in real life, we're not looking at any legal tricky stuff. We're just looking at good English. We're just looking at whether the defendant actually did in fact cause the damage. So the test for proving this is but for the defendant's lack of care would this damage have occurred. And that comes from the English case of Barnett and Chelsea. And that was affirmed in New Zealand in this Invercargill case. So I'm going to leave that. And that is sufficient for the law at this stage. Some people get confused on the way this is worded. It's like but for. It sounds weird. So another way you could word it is like, except for the defendant's lack of care, would this damage have occurred? Or if the defendant did not do the action with a lack of care, the damage wouldn't have occurred. So it is a simple test, but it sounds weird. Okay, so we've got the law there, and let's have a look. So she was out drinking, she accidentally banged into the car. Yeah, totally. It's pretty basic, I think. So we wouldn't need to spend too much time on this in an exam, because you wouldn't have, like, the thing with answering these negligence questions is when you look at my notes, look how much work I had put into causation. In fact, I had read like so many cases about it, right? But that doesn't mean I need to put it all in, because there's all sorts of stuff that I could talk about, and I could show off to the lecturer that I know heaps of stuff and that I've read like an additional, what is this, like 8 cases. But it's not relevant, because this is just a really simple, like, she banged into his car, she caused damage. So I am going to show off my skill by saying less and moving on to an area that might require more attention. So in this situation is going to be yes. I did put in this little bit about Timmy's car being pretty crap, and he might have potentially thrown it out anyway. So where will that come under? I'll look at my notes. Does that come under... okay, I think that's going to come under the next section. We're just looking at if, in fact, the damage was caused by Erin, and we can say yes, but for Erin's careless driving and banging into Timmy's car, we can say it appears on the facts that but for... That kind of does sound weird, on the facts. Based on the facts, that but for Erin's careless driving and hitting into banging and hitting into Timmy's car, the damage to Timmy's car and license plate. Maybe we should be more specific, because he has other damage to his car. The damage to Timmy's back bumper and license plate frame would not have occurred. There's no novus actus interveniens, which is someone getting in the way and breaking the chain of causation. I don't think so. So we'll leave that there. So simple. Boom. Let's move on. So remoteness. Remoteness is sometimes called causation in law, which I think makes it sound more confusing than it is. But it is, if I were to break it down really simply, I'd say, was the type of damage foreseeable? So what we're looking at here is the damage to the back bumper. Was that foreseeable? And was the damage to the license plate, which was gold plated, had neon lights around it, and was worth $2,000, was that foreseeable? So, is the kind of damage suffered reasonably foreseeable at the time of the breach, or is it too remote? I'm going to quote these ones. Next, it must be shown that the type of damage, the damage to the back, the damage to Timmy's car and license plate frame is was reasonably foreseeable at the time of the breach by someone in Erin's position and not too remote. So I'm going to quote the wagon mound and main guard for authorities on this principle. Next, it must be shown that the type of damage, the damage to Timmy's car and the license plate frame, was reasonably foreseeable at the time of the breach by someone in Erin's position and was not too remote. Okay, so this one might require a bit of thinking because we have the damage to the car. The car was likely to be written off because of the bad crash, and it was worth about $3,000. So I think we can say, like, yes. Or the damage to Timmy's car is likely reasonably foreseeable. A car being worth $3,000 is foreseeable. It's like a pretty cheap standard price for a car. Well, actually, really cheap. So we can say the car damage is foreseeable, right? If I look at my notes, there's this eggshell skull principle. Just saying, like, even if the person, like, let's say you punch someone in the face and their skull is made of an eggshell. It's so thin it just crumbles. That is, it doesn't matter that's not foreseeable. If the type of damage is foreseeable, the extent doesn't matter. So it's foreseeable that if you punch someone in the face, they're going to get hurt. And it doesn't matter that you didn't know that person was particularly frail. You would be responsible for the whole damage. So I'm going to add this to law. And I want to apply this because the car was a lemon or whatever. It was bust and he was going to get rid of it, potentially anyway. But that doesn't, I don't think that matters because she still caused the damage, even though the car was, I'm going to use the comparison of even though the car was an eggshell, not like a good, strong, hard skull, she still damaged it. Would he have gotten rid of it anyway? I guess that's like a bit subjective. Like maybe he would have fixed it. So I guess there are a few ways you could take that, but I want to take it like the unexpected frailty of the car doesn't negate the fact that she caused $3,000 worth of damage. That just feels logical to me because I'm just thinking like in reality, if I whacked into someone's car, I should have to pay for something. It doesn't matter that they might have gotten rid of it. It just seems logical to me. So I'm not going to like overthink that. I'm just going to use my logic and say also the unexpected frailty of the car. Or maybe that's too complicated. Maybe also I feel like there's something else I'm missing. I want to apply like a Sinbad reasoning. So I'm actually going to add that into my law section, but you could just add it into the, oh, you know what? I'm not going to because we're emulating an exam. So I'm just going to keep that here. So I've got, as for the license plate frame, it is likely Erin would be responsible for paying the full price of the damage to it. Although it was a particularly extravagant license plate frame due to it being gold plated and having neon lights and being worth about $2,000, it is foreseeable that if someone hit into the back of another's car, that the license plate frame would be damaged. Therefore, as a type of damage is foreseeable, which is being hit into the license plate frame, the extent of the damage not being foreseeable is irrelevant. In other words, as the type. All right, done. Okay, and now we've got defenses. So, a defense could be, was he doing anything negligent? Contributory negligence is always a good one because, you know, if he was doing something wrong, like a defense would work like we've pretty much proven Erin's liable, But maybe in court, instead of paying 100%, she would only pay 80% of the cost of the damage if Timmy was doing something liable, also negligent. But it doesn't look like he was doing anything here. Nah, he's all good. No contributory negligence. He wasn't doing anything illegal. That's a good one to bring up. Extirpia causa, if they're doing something illegal. He wasn't really assuming a risk. Like, I guess driving is technically an assumption of risk. But this is more like, if you're going boxing, don't like complain that you got hit in the face. Yeah, so I'm going to say no defenses that are obvious to me apply. So I'm just going to leave that at that. And then I guess I need to add a conclusion. So I'm going to say all right, so that is that. That's an answer. So we've ticked off, we'll go back to our possible plaintiffs and defendants. We've ticked that one off. And now we need to do Erin versus the hospital. I'm just going to make it clearer that we've started with Erin versus Timmy, because I love a subheading. Everyone who tutors with me knows I'm all about the subheadings because it just makes it so much easier for the marker. So now we're going to do Erin versus the hospital. So since this is our second one, we could breeze through it a bit faster. I don't want to repeat any of the law unless we need to bring up new law. I would rather just leave it, because we don't need to write the same thing twice in an exam. Like, I'm not going to need to say duty of care. That'll take too long. But we do need to apply it again. So I'm just going to say I want to say, like, I'm just going to breeze through this a bit because it's getting a bit long. I'm going to say there might be a policy reason negating her from owing a duty of care, because it just might be a bit unforeseeable. No, that's a better way to put it. Maybe it's not a policy reason. Maybe it's an and one. It might be a bit unforeseeable that someone in her position would cause like $50,000 to be stolen from a hospital when she was just driving and banged into a car. Like, imagine you're driving. You would totally expect to pay for the damage to someone's car. Like, the license plate, you'd be like, oh, seriously? Like, what a joke. But, you know, it is foreseeable. But, like, that you would cause someone to be late to work and that $50,000 would be stolen? That's unforeseeable. It's unforeseeable that you would be liable to a hospital. So I don't think they're neighbours. I don't think they're proximate. There may even be a policy reason, I think, as well, because, like, maybe the courts don't want infinite liability. Like, if you, like, they don't want you to just be on the road and be liable for anyone to do anything. That's, like, how do I say that, Clara? You know, you're driving and they don't want you to take on that assumption of risk if you're just driving to be liable for, like, tens of thousands of dollars to a institution. So I'm going to say no duty of care. I'm not going to go into writing it longer because we've already kind of gone over that. Standard of care, was she careless? Yeah, we've already, like, we could say, you know, as stated above. So we don't need to go into this all again. We don't need to go into the law again. We don't need to apply it again. It's the exact same. Like, yeah, she was negligent when she drove. Causation. Okay, here is where we're probably going to need to go into novus actus interveniens. So, did she cause the accident? I mean, maybe in one reading of it she did. But if we look at a novus actus interveniens, it means someone has done something negligent. As a result of this negligence, something else happens that was not a foreseeable, likely, or natural cause of the original person's negligence, the defendant is not liable in this situation. So I'm going to add this law in here. That's applied. So we've got, we don't need to say the but-for test again because that's above. Yeah, so although in some sense, but for Aaron's actions, Timmy would not have been late and the loss wouldn't have occurred, it is still unlikely Aaron caused the loss. This is because it could be seen that the bank robber was a novus actus interveniens, breaking the chain of causation between Aaron's negligent driving and the damage to the hospital. Likely no causation here. And if we haven't got it here, we can say see above law. We've got, it was definitely too remote. It is just not foreseeable that if you hit into someone's car, they're going to be late to work and then a hospital is going to have $50,000 worth stolen. So we're just going to say like the damage is not foreseeable. If the kind of damage is reasonably foreseeable, it doesn't matter that came about in an unforeseeable way. So defenses. I feel like we could have a few defenses here. I feel like there's a bit of contributory negligence. Because like on behalf of the hospital and also the Timmy, but mainly the hospital, like they are so yeah, the hospital should have had other systems in place to protect against the robbery, like a backup staff member, security cameras, something else, and Timmy should have rung ahead to warn them that he was going to be late. So you can see that even though like it's obvious she's not responsible, I still went through each step. Even though I did some of the steps quickly, you still have to go through it. It's a mathematical equation here. It is unlikely Aaron will be liable under the tort of negligence to the hospital. So that is the answer. We've done both, and what you really need to do in an exam is be super aware of how much time things will take, and do not spend too long on an area that's not very contentious if you know there's a very contentious area coming up. So for example, in this problem question we had a lot about remoteness, but like for example there was not much in defenses for the first question, so we wouldn't have wanted to spend heaps of time in defenses and just said, does contributory negligence apply? Contributory negligence is this. No, it doesn't apply. Like, we don't want to do that. We don't want to waste our time because we had to talk about so much here. Because I can type it very fast, but imagine writing this in an exam. That definitely would have taken a long time, like an hour. Thank you so much for watching. That was how to answer a tort of negligence problem question in an exam using my style. Of course, check with your lecturers and your markers about the style of your own university. And this is specifically for New Zealand law students. Although the test is the same across the Commonwealth, there might be little differences in your jurisdiction. So please double check with your lecturer and always follow what they want, because they'll be marking you at the end of the day, not me. Anyway, thank you so much for watching. Please download my free template on how to answer tort of negligence problem questions. And also you can download my notes, which I use in this video, on my website. They're 40 New Zealand dollars. Thank you so much for tuning in, and see you next time. Bye.